Excellent. Welcome to the second hearing of the Committee's review of the Design and Building Practitioners Act 2020 and the Residential Apartment Buildings Compliance and Enforcement Powers Act 2020 and related draft government bills. I acknowledge the Gadigal people of the Eora Nation, the traditional custodians on the lands on which we're meeting today, and pay my respects to elders past and present and celebrate the diversity of Aboriginal peoples and their ongoing cultures and connections to the lands and waters of New South Wales. I also acknowledge and pay my respects to any Aboriginal and Torres Strait Islander people joining us today. My name is Abigail Boyd and I am the chair of this committee. I ask everyone in the room to please turn their mobile phones to silent. Parliamentary privilege applies to witnesses in relation to the evidence they give today. However, it does not apply to what witnesses say outside of the hearing. I urge witnesses to be careful about making comments to the media or to others after completing their evidence. In addition, the Legislative Council has adopted rules to provide procedural fairness for inquiry participants. I encourage committee members and witnesses to be mindful of these procedures. So I now welcome our first witness for today. Thank you so much for making your time available to us this morning. Could I ask you to please state your name and position title and then swear either the oath or the affirmation?
My name is David Chandler and I'm the former New South Wales Building Commissioner, but I now am the principal of a company that I own called CE Advisory, so I provide construction industry advice.
Thank you. Could you pull your microphone just slightly closer and then either the oath or the affirmation?
I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Excellent, thank you. Mr. Chandler, would you like to commence with a short opening statement?
It's been an interesting year going from being the rooster to the feather duster, but that's a part of changing roles in a career, so it's been interesting to spend time now with the industry and get feedback as to how they're seeing the reforms that have occurred since 2020 really, and I can report a pretty positive experience. So while there'll be some quarters who want to throw up pain points, I think I can report broadly that designers are far more enthusiastic about their role now being respected, and that the value of their work is being considered in a way that it should have always been, and that constructors now are really been able to sort out, they've got off that race to the bottom and they've now started to go back to where they'd like to be, and they're reporting that from their point of view, the ability to have a complete set of designs as it was considered by the DBP Act before they start construction, design and then build, as opposed to build and then retrofit the design, has really changed the setting. So people are telling me, and I'm observing in the field, that projects are going up faster because they're now being able to start with a complete kit of design where people can actually say, well, we now know what we're going to do, we don't have to make it up along the way. And I'm getting that from all forums, and last night I addressed 60 members at the Master Builders Association, and it was a universal feedback that they're saying that the industry from their perspective is now a whole lot more sane, and while there's always going to be issues, that they feel the reforms have made a huge difference.
Thank you. I'll just ask one question and then I'll throw to whoever on the committee wants to ask. I guess there's a narrative in the media and with some politicians that the buildings are being held back by red tape, they're being held back by too much regulation and too many rules. What's your sort of take on that?
Chair, I think that there is justification in the concerns regarding planning. I mean, planning, you can see, has just been so blocked for so long, and that the changes that are being made, and I understand that they've got crossbench support for those changes, they are long overdue. Now, like all of these things, are they going to go too far, or do they go far enough? Only time will tell. But from what I can see is that the planning red tape and the mechanisms of improving the planning side, which wasn't my remit, is making great improvements. And the exciting bit is going to be the introduction of AI into this, because planning is actually quite binary. So it's going to be interesting to see how AI makes the process even more accountable and more productive. From the building side, of course, the conversations around things like the NCC are another conversation, and And the NCC is a bit like a camel with so many humps that nobody can ride it, and it's really been constructed over so long that people have forgotten the journey that it's been on. NCC 22, I'm told, had 14 state and territory ministers in the saddle during the course of making NCC 22, and of course each of those ministers, elected ministers, would have come in and injected their own particular preferences into the way the ABCB did its work. I agree that there's a considerable amount of operational improvement you could apply to the NCC. I think it could be made far more user-friendly, far more accessible, and I think that's certainly the priority. Winding back on important improvements to the codes like waterproofing and fire. I think those things that we worked so hard on during the last 5 years to say, can we elevate at least lifting the standards or putting standards in place where there are no standards. For example, there were no standards for basement construction. So the reason that we've got so many basements that leak is that there were just no standards that the industry could turn to for basement construction. And I think in time, Standards Australia will adopt the British standard, which is actually quite well established, and everybody's comfortable with that. So look, I'm not sure what anybody's thinking they want to take out of the NCC. There's some advocacy from the lobby from the Modern Methods of Construction group to say that some of the building standards are problematic to them, and I'm saying, well, are we going to have two classes of buildings? Are we going to have a traditional building built to a high standard, and are we going to have modern methods of construction that might be built to a different standard? And I've simply been inquiring of that part of the conversation, saying, well, what standards do you want watered down to accommodate you? And to date, nobody's been able to present any. So I think we need to acknowledge that modern methods of construction are going to be part of the future. We're still shaping what that looks like, and my work in the advisory space has been able to identify quite a number of potential weaknesses in manufactured buildings, particularly Class 2 buildings. So I'm less concerned about Class 1, but I do carry concerns about the fact that there's so much push to get these buildings into play that some of the issues around them, like waterproofing, like fire, like resilience, need to be attended to. So that would be a snapshot.
Thank you. I'm just looking to the committee for questions. Mr. Farlow.
Thank you very much, Mr. Chandler, for being here, and of course thank you for your work as Building Commissioner. Of course, we're looking in this inquiry, it is a statutory review of the Design Building Practitioners Act and the Residential Apartment Buildings Act, but of course the government also has on the table a new building bill. Just interested in your thoughts. Have you perused that new building bill, and do you think that it picks up everything that is required from those two acts?
Scott, I've tried to leave the building bill on the table as I walked out the door and not to become a commentator on it. So I'm mildly aware of where it's headed, and I know that the industry wants it, by and large. There's always going to be noise that says, oh, they don't want this or they don't want that. All I would comment on the building bill is that the sooner it sees certainty, that would be helpful, because last night when I was at this event, it was if the questions were, I was still the building commissioner, I'm saying, guys, it's not my space anymore. But there's a great deal of interest of when it will materialise, because that would at least give certainty. And some sides want some extension, and one of them was from some Class 1 builders in the MBA that were actually thinking that extending the DBP Act into Class 1 would be desirable, and I said, well, my last experience was that that was unlikely, and I still have the view that it's probably not what we need right now. I think you need to get Class 2 and 3 really sorted out first and deal with the ingestion of modern methods of construction. So as you know, in the building bill, there is an element of dealing with modern methods of construction. New South Wales would be the first state in Australia to actually put that on the table and make it happen. So I think if that crystallised, that would be a good outcome.
And to that point, in terms of the delivery, I guess one of the messages that we received, I'd say fairly universally, but there was some deviation from it, that when it came to the building bill as proposed, that there was so much that relied on the regulations that there needed to either be some form of statement of regulatory intent that was shared with the industry prior to its introduction, or that the regulations themselves should be finalised and be part of it. Just interested in your perspective as to how much hangs on the regulation of any of these bills, so to speak, outside of the legislation.
Well, having dealt with what I had during that period, I think making sure that the regulations are aligned to the legislation is very helpful, and all I can do is talk about my past experience, and that is that building regulator capability to actually stand up legislation is something that always is often lagging. And so it would be really good to see how the regulations were going to work so that in fact the regulators' capabilities could be stood up at the same time. Now there was work to do in the regulatory capability, particularly at the technology end of making sure that the technology systems were up to speed. Certainly when I came in as Commissioner in 2019, there was quite a lag of old and very broken technology, and that went leaps and bounds in that period of time, and it would be good just to see clarity of the legislation, the regulation, and then the capability build of the regulator. That would just give everybody, I guess, more peace of mind, in my view.
And Mr. Chandler, last question from me. In terms of the existing acts, the Design Building Practitioners Act and the RAB Act as well, what were some of the deficiencies that you found within those acts in your role, or things that potentially constrained you from being able to execute your duties as the Building Commissioner?
I didn't feel terribly constrained, to be honest. There were some pieces of the RAB Act, for example, that that didn't work in the first outing, but we were able to bring those back, and there was very quick amendments to the regs or the legislation to accommodate those. So one of them was when we first started issuing orders, and it wasn't entirely clear that basements were part of a Class 2 building. That needed to be clarified that it was, so that in fact orders that we were issuing on basements, which were desperately needed. So those, I think the Parliament and the Minister was very agile in dealing with those sorts of operational issues, that if there were unintended consequences. And on the other side, there were give-backs as well. And I think initially the DBP Act was silent on things like staging of major projects, so that in fact design develops for a project to allow it to get out of the ground and maybe get halfway up and then get to the top, particularly with some of these very big buildings. So there was an accommodation of staging, and that made the work of the regulator a lot easier, because instead of trying to look at a whole building, we're able to look at parts of a building. But it did pull everybody into focus to get them to understand that if you were signing off on, say, a third of the total building in the basement, it had to be capable of receiving the building above it. So you actually had to complete the design for fire systems and electricity and water and all of those sorts of things. So so there were more practical things. I don't think we ran into too much trouble at all, other than those who felt they were being leaned on, complaining that they were being overly pressured. But you had to have seen the state of some of the buildings, Scott, that I saw. I mean, I've never seen buildings like this in my life, as I've said regularly at these hearings. That and people forget that, in fact, the lives have been broken of some people who bought into these buildings, and I'm talking about seriously broken, including the ones who finally departed from Mascot Towers. And so I always took comfort in the fact that decisions I made under the RAB Act were able to be appealed in the Land Environment Court. And so when I started to make a decision about weighing up, would I go with a developer's perspective or a consumer's perspective, and I went both ways. If I was sort of vexed about that, I would tend to go to the consumer perspective, simply because I knew that a developer could have my decision overturned in the Land Environment Court. So I gave plenty of reasoning as to why I made a decision one way or the other. And we didn't have any of those challenges because the reasoning was quite clear, but the option was always to go. So I think developers and builders had certainty in terms of their ability to appeal. When the door closes on a consumer, it really does close.
And last question from me, you of course mentioned modern methods of construction, those being encompassed under the new building bill, but at the moment, what are some of the impediments for modern methods of construction, and what are some of the areas that you're hearing from industry they'd like to see changed, which may be able to allow more modern methods of construction but not necessarily dilute the quality of buildings?
I think the first statement we should say is that we don't want two classes of buildings. I think if we're going to have two classes of buildings, then what are we going to have? So let's assume that they all have to be fit for purpose and compliant. They need to be trustworthy and resilient. I've been on the prefab journey for over 15 years because before I was building commissioner, I set up the Centre for Modern Construction at Western Sydney. So I'm very much on this journey and very much pro the shift to, in fact, improving productivity and the way buildings are made more generally. But what I was concerned about, and I delivered a paper to the prefab conference in, I think, 2017, which said modern construction's customers can't be modern construction's guinea pigs. And there's a culture inside the people who are the front end of this, is that get everything out of the way. It's hard enough to invent these buildings and to bring them to the market. And my view is, well, there's another end, in fact, that these buildings actually have to prove themselves. And I'm not really, I guess, some of my commentary is not that well accepted by the saying, guys, I'm going to continue to look at the progress of the modern methods of construction through the consumer's eyes. And I follow what's happening around the world. So in the UK, there's buildings that are now not completed, that have been stood up because they were non-compliant before they were finished and they were just stopped. There's some buildings that have been built that have failed shortly after, and they're looking as though they've got to be demolished. Another Mascot Towers would be on my nightmare radar. I've got a building that I'm following carefully in New Zealand where it was a 540 apartments development over 5 towers, and I inspected that building in March 24, and it was 6 months away from being completed, and it's still not finished. And the reason for that is that the authorities have taken a much greater interest in that building, and some of the commentary I probably made about it provoked that. And I was just unsatisfied that, in fact, that building wasn't going to be resilient for the occupants, and that building was going to be a strata building. And so, again, I'm less worried about build-to-rent buildings where you've got a sophisticated single owner, but if something's going into build-to-sell, that's the strata market. And people have got to face into that and understand what that looks like and what the risks are for strata community owners.
Thank you.
I've got Ms. Fairman and then I'll go to Mr. Latham. Ms. Fairman.
Thank you. Can you hear me?
Yes.
Yes, we can.
Thank you. Mr. Chandler, good morning. I just wanted to get your view on a number of witnesses have talked to us about their concerns. This is with the new building bill and basically the abolition of the Architects Act. And obviously we've heard from architects that they're worried that that will lead to a drop in the quality of building designs, that they're not building designers, and wanting to us to ensure that certain things are maintained if in this new building bill. What's your view on their concerns, and are you worried in terms of this new the new building bill and the abolition of a number of acts that there will be a decline in the quality of building design?
I think you can split the quality conversation into two parts. One is the beauty of buildings, and then the other is the appropriateness of the built building itself. So what was clear in 2019 was that the industry had been on a journey to downgrade the role of architects in the creation of buildings I called it a focus on the big lines and a lack of focus on the little lines. And so the big lines are the architectural imaging of a building, which developers use to promote the building and attract their depositors in the first place, and then a complete shutdown of the detailing of buildings. So that was all of the stuff that you needed that was required under the DBP Act to get it properly documented so it could be properly built. So it's really, design quality, I think, fits into two parts. It's the beauty of the building or the appropriateness of the building, and the second part is the fitness for purpose of the building. So I'm more concerned about the fitness for purpose. I personally think the architects are jousting at windmills a little bit. I don't think there is likely to be any diminution of their role. I think that buildings, the process for consenting buildings and building buildings going into the future is going to very much have a mind to both the appropriate look and place contribution a building will make. I think we're seeing some pretty exciting building designs coming through at the moment. So I think there's a bit of jousting at windmills there. But Kate, if I could say that the other thing that I think is missing in the conversation of architects, and I've taken this up with the architects at several occasions, is that architects don't quite understand what's happening in the world of AI and just how much binary type design activity will be overtaken both for engineers and for designers. And so I think there's some very interesting publications on that, some recent work by McKinsey looking at the future of construction, actually talking about the changing value pools that everybody's putting in. Now, if there's one thing that's going to cast this dramatically into a new light, will be the introduction of modular construction or other prefab, where in fact when those buildings are designed and made offshore, we've got to make sure there's the same amount of rigour applied to those buildings so that when they come here, they nestle into a trustworthy set of buildings in Australia. Now, the role of the architects and designers in that at this stage are not clear, and where I do advisory work at the moment is that I actually advise clients and builders about the sorts of issues they need to navigate. So I think at this stage it would be good to see the architects paint a landscape of what they think the industry will look like in 10 years and then put their problem in that context.
That's fascinating, actually, the whole the role of AI in terms of building design. It's another line of inquiry entirely for us, I would say. Mr. Chandler, also we've heard from some witnesses about the DBP Act and its role in potentially increasing the costs for projects for building. What's your view on whether the new building bill, and again, I don't know if you know this, but this committee has had difficulty actually getting the draft copy of that bill to have a look at. But what's your view on whether the draft building bill is going to address the concerns around the increased cost as a result of the reforms from 2019 and onwards?
Kate, I would say that first of all, I have yet to see anybody demonstrate to me, and I'm a builder, so I can actually pull these arguments apart in very quick pace. And I have yet to see anybody demonstrate to me that when a building can be built faster simply because it's got clearer documentation ahead of it, that in fact there's anything but upside, because there's reduced rework, having to go back and do work again when it doesn't comply. There's an ability to actually order the work in a consistent manner and in a confident manner, and bring the components of the building together in a far more organised way. Now that's saving time. And I can tell you that the greatest cost on a construction project these days is the duration that it takes once you've started to build. And I'm now getting feedback, and I haven't stepped back from my engagement with the industry because I'm really just picked up what I was doing prior to appointment as Building Commissioner. So I've spoken to dozens of builders to actually get a line of sight to what they're telling me about their projects, and they're saying, David, you need to understand building now is far more predictable and manageable, and people having a clear set of road rules actually makes it easier for us right down the trades. I've just come back from giving a series of presentations around the country, Sydney, Brisbane and Melbourne, on waterproofing, for example, the fact that you've actually got to do waterproofing properly these days. And I've got developers coming up and saying, look, we now know that we're going to be held accountable for buildings that fail. And so we need to understand how to do it properly in the first place. And so there's this growing group of people now that are providing expert advice in waterproofing, as there is with fire. So I think getting it right the first time is essential, and it's always cheaper to build it right the first time than it is to go back and do it again, as my colleagues at Botany discovered on that Top Place project, where we had to pull out 280 bathrooms back in 2020, and the developer advised me that they felt that they had saved about $1,500 per bathroom by cutting corners. To go back and fix those bathrooms before the project was finished, they told me that it cost them $15,000 per bathroom, so 10 times what they saved. And then in discussions with strata community and other owners, I was led to the view that fixing the same problem in those bathrooms post-occupancy, that's in the hands of an owner, was $35,000. So nickel and diming, that's cost shifting. That's not adding to the cost of construction. That's taking what construction done properly should look like. That's cost shifting it onto an owner. That's moving $1,500 worth of nickels and dimes over to some poor owner down the track. So if someone says to me, well, the cost of construction went up by $1,500 a bathroom because we took that back and we put it back where it should have been, then that's the answer to your question.
Thank you.
Mr. Latham.
Thank you, Chair. Thank you, Mr. Chandler, for your time today. You cited some examples from overseas, but since these issues became prominent in New South Wales in 2019, how many buildings have we had like mascot towers that have fundamentally failed and required evacuation of residents?
There are still some buildings which I can't name that have got prohibition orders on them that, thank goodness, they never came into occupation at that stage. But you'll be well aware of the Murhi project at Parramatta, and the fact that we issued prohibition orders on that. That could have well been another example of the Murhi building at Auburn Road, where to this day the owners are under some duress in terms of that building. But the Murhi building at Parramatta was going to present problems with continued occupation in the very short life in its journey. Now, we ended up negotiating with the receiver manager for that building because Murhi put themselves, they phoenixed in that stage. And we negotiated with the receiver manager that instead of that building going into the build-to-rent market, into the build-to-sell market, that it would go, that the financiers would hold that building in the build-to-rent market for 10 years, so it could exhibit all of its potential fault lines in that time. Now, on that basis, I was happy to lift that order. But there are two other buildings that at this stage I can only hear from what's going on around the traps as to where they're at. I'm glad I don't have to make the decision to lift the order on those two buildings, because I know that there's no upside for a commissioner who would lift an order on a building, certainly like one of them, that in its very short life it immediately started to exhibit the sorts of issues that we saw at Mascot Towers. And it would be a very unwise commissioner that would prematurely lift orders on a building that still was highly risk prone. We didn't get them all. I found some buildings that were highly compromised, and we took an approach to say, how could we work with those owners' corporations to keep those buildings occupied? There was another building at Auburn that was an example of that. And when I first was told about it, the fire brigade reached out to me and said, Commissioner, we're uncomfortable with the continued occupation of this building. And I realised the damage that would do, so we immediately called a meeting of all of the parties, and we sat down and worked out what was needed to do to ensure the continued occupation of that building, and it wasn't structural, thank goodness. It was to do with fire and life safety. And we reached a position that a certain amount of work would get done within 4 to 6 weeks to bring the core issues under control. But during that period of time, they would put a 24/7 fire warden on that building to make sure that if there was in fact an event, that in fact there'd be a quick and appropriate response. So look, the number of buildings out there and other mascot towers, I think, but for the grace of God, we haven't seen it, and hopefully we can avoid it.
So your answer's one, mascot towers.
No, I'm not saying to you that. I'm saying to you we've managed to discover buildings that would have gone into operation had we not pulled them up, that would have potentially been another mascot towers. That was the proactive regulator doing their job.
Yeah, but my question was, how many buildings have we had like mascot towers where they fundamentally failed and the residents had to be evacuated?
Mascot towers is the shining example that you don't want to happen again.
Okay, so your answer is one.
Well, if you want a number like that for that question, the answer's one, but I'm saying to you that there are and were a number of buildings that could have any one of them been.
I heard all that.
Okay,
You
thank
seem
you.
to be in pain in giving the answer as one.
Sure, okay.
Okay. Now, in terms of consequences, is it fair to say that through your work, it's given rise to what might be depicted as a defects claims legal cottage industry, sort of the equivalent of ambulance chases, where a bunch of legal firms have now popped up, headed by an outfit called Chambers Russell Lawyers, who specialise in finding out about defects, going around and saying to the owner corporation, we can sue big time here and get you a lot of money. And some of these legal matters are now extending towards 6 or 7 years without resolution. So what should we do about that problem?
Well, first of all, these ambulance chases were productive and alive when I came in, and I can tell you that my mission was to actually close them down as quickly as we could. So in the RAB Act...
The law firms?
Yeah, close down the matters, the litigation matters.
Litigation, right.
Okay, so I don't need to mention that firm, but they were amongst others, and the RAB Act was effectively deployed on through Project Intervene, where 150 or more projects, strata buildings, came and approached the Commission and said, well, we've got serious defects, and can you use the RAB Act to in fact enforce the remediation of these buildings? Now, we built our capability in Project Intervene, and I haven't seen where it's up to since, but there were at least 150 buildings in Project Intervene that were facing into this sort of crisis where there was extreme litigation, and one of them, just trying to think of the name of it, it was the Icon project that, and I just can't recall, Otto 2 it was, and that was well into litigation, and it had been, the lawyer had been stoking the fires there for nearly 3 years and spent $750,000 and not one single thing was fixed. And we exercised the RAB Act and actually reached a situation where the developer put their hand in their pocket and made a significant contribution to that building. Now, one of the pleadings I got back from the lawyer was, well, you've issued the order to get the building finished, but why don't you issue an order for costs so we get our money back? I said, I'm not in this to issue orders for your costs. If you want to go on the folly of setting up your cost pipeline, that's another matter for you. But they said, well, you effectively deconstruct our matter. If you get these serious defects fixed, all that's left is what I would call the consumer type defects. So look, the building bill does have a piece in it. The last time I saw it, and I haven't seen it since I left the office, was that a owners corporation will be required to notify the Building Commission of serious defects and its intention to actually have those resolved. That will immediately provoke, I hope, the Building Commission to go out and inspect those defects upon notification from the owners corporation, and they would need a ticket to actually then go off to proceedings to actually make a claim. So hopefully there's a safety valve in there that says owners corporations, you're obliged to let the Building Commission know first, and you'll be required to get a ticket to move into a litigation process. Hopefully that can come into play quickly, because I think that would be a really helpful exercise. And we should know that owners' corporations historically have been very reluctant to notify the Building Commission that they actually have serious defects. They had a view that maybe that wouldn't lead to an outcome. Well, it did progressively lead to more and positive outcomes over the time of the reforms. And owners have been far more probably able to, or confident to actually go to the Building Commission and say, well, we do have these matters. Can you come and have a look and see what we can do to avoid going down the other trail? So the building bill should make that a bit more realistic, and I think those owners' corporations that have been sitting on serious defects and squirreling them away are suddenly realising that they have to declare those defects when they sell their apartment or their building. So it's not a case of, oh, let's leave now and let the next monkey buy those defects. They now have to disclose them. So I think the setting has changed dramatically. Are we ever going to make these sycophants go away? They'll be on the fringe, but I think
sycophants or the ambulance chasers?
The lawyers.
The lawyers.
The bloodsuckers, I call them.
Bloodsuckers, yeah, that's a good one.
And but you know, the other thing that will quell that, Mark, will be the introduction of latent defects insurance.
Yeah.
And I can tell you that I have been invited to own openings of buildings where latent defects insurance is on the table. Now that's a first response to defects. That's, you know, not a last resort, but a first resort response. So latent defects insurance, you know, I recall sitting in a meeting with you back in 2019 where the conversation, I think it was a briefing on the coming legislation, and it was like, you think you're going to get the insurers back into the industry anytime soon? Good luck with that. 2023, they were all back. So
right.
Now on the table.
Okay. I've been in too many meetings, I can't remember that one.
I do.
I do, actually.
Can you help me? Thanks, Chair. I'm just a poor, humble legislator. The bill that the witness is referring to, that's the one we haven't seen yet? Is that
We
right?
have not seen any official draft of the bill, is my understanding.
Okay.
Nor have I.
I've only seen unofficial
you've
drafts.
got one off the back of a
No.
truck. Our trucks aren't so productive.
No, I
in that
closed the
space.
door on that as I walked out.
Did you? Okay. Righto. Well, the process you're describing and speculation about the new bill, will it be as effective as the Queensland process in closing down these defect claims within a reasonable period of time through a tribunal process? Because apparently here in New South Wales there are some ambulance chasing, blood-sucking firms who have lodged defect claims at a value greater than the cost of the building itself. So obviously there's a problem here, and we need to have something like Queensland, don't we, to close it down?
Well, I wouldn't think that Queensland's a basis for a carbon copy, but that's my personal opinion, because I think they've been effective in Class 1, but I think they've been pretty ineffective in Class 2, but we'll see. But my social media feed says, David, if you think New South Wales had this on their own, Queensland got the same disease, and certainly you can see what's happening in Victoria right now, is that they're facing into this and making the reforms, and there's a very positive shift of consumer response there. But I know of the claim that you're talking about, where the claim is in fact higher than the value of the building. And now, first of all, I think that building's got defects. I've seen that building. The building's got defects. The cost of fixing those, I don't know. But I do believe that the lawyer in this case created a situation where they waited till they just got on the Supreme Court list and waited till the 10-year period stopped or passed, and so there was no opportunity for the RAB Act powers to be applied.
Right.
Now that's a really tragic situation, and I'm hoping that the requirement to get a ticket, at least from the Building Commission, before you start matters in the Supreme Court is going to be a new, another way of closing this down. So you'll have the 10-year warranty insurance, you'll have a requirement to tell the Building Commission about it first. The Building Commissioner will then be able to do proactive inspections and issue orders, and hopefully those powers will start to mitigate the sorts of concerns that you're expressing, I agree. And I have been a most unpopular person in the legal fraternity because I've suggested to them by 2027, 28, that they should all start taking their kids out of private schools because the cash flow, the rivers of gold are going to close down.
Yeah, well, you've done one hell of a job. As I go around, you've got more detractors than me, so at one level that's good to hear, but at another, you've been across the sector. So thanks for your answers.
Mr Primrose.
Yeah, Mr Chandler, you gave some excellent evidence at the beginning in relation to the issue of modern methods of construction. In light of the legislation that we're reviewing as part of this committee, are there any provisions that you believe need to be changed, improved, altered, etc. in terms of that, and perhaps given what you may expect will be modern methods of construction over the next decade or so?
If I give you an example of how the sands are changing, when I was first appointed, the regulators had a sort of view that all buildings were made in New South Wales, and they didn't really have a line of sight to the fact that buildings are now coming from all over the place. So we will have bathroom pods coming from Victoria and other places. So there's different elements of buildings coming from other jurisdictions. And as we move more to sourcing offshore, and I'm not against that, what I'm really interested in is, are we able to build a chain of custody of the inputs into those buildings that when you look back up that chain, you can actually see that in fact there's a bunch of compliance inputs. Now, the sorts of response I got in the early days from a certifier, for example, was bathroom pods coming from Victoria. And I said, so how are you as the certifier doing your duty looking at 10% of the bathrooms? And he said, oh, well, fortunately, there's the very first part of this building is on a concrete slab before we actually went into the building where the bathroom pods started to arrive, and there was just 10% of bathrooms on that slab. I haven't looked at any of the bathrooms coming from Victoria because I've done my job. 10% of the bathrooms I have seen. So that sort of threw up very early on the fact that this line of sight going into multi-jurisdictional supply lines, first of all from national lines and then international, so that project at Parramatta, the Murhi project, the bathroom pods in there came from Dubai, and that they were just simply non-compliant. We don't have a capability at the moment to look back up the supply chain and actually see what that looks like. And I would commend a couple of the early players who are sort of trying to line up to be in a market where they understand that they've got to demonstrate multi-jurisdictional compliance. They're actually building those capabilities now, but they're going to be business-owned IP as opposed to industry-owned IP. So I'm concerned that that's going to disenfranchise those people who don't have that capability. So that would be an area where I think we've got to give some attention. So I think I left the office feeling that you can attend to those matters that have been sort of problematic for 20 years, but for goodness sake, turn your mind to those things that could be problematic in the next 5 years, because you wouldn't want to be back in 20 years from now having to do this again.
So would you suggest that that could be an area in which this committee should be looking at making appropriate recommendations?
I'll answer that by pointing out another aspect of this, and that is co-regulation. I think the days of society thinking that the public regulator would do all of the lifting in terms of compliance is just simply unachievable. So when you look at multi-jurisdictions, you start to look at and say, well, who's going to do most of the lifting in that space? So as you're aware, we introduced ICERT. That, by the way, has just been taken up in the ACT and is likely to find its way into Victoria. It's certainly at the forefront now of banks are saying, we will favour lending to developments that have actually got an ICERT rated builder or an ICERT rated developer. And the feedback I get from the industry is that ICERT rated builders at the moment have got pretty healthy order books because the lenders to some of these people that were untrustworthy are paying a very high price. There's one lender at the moment that's got over $1 billion worth of defective buildings that can't get to the end at the moment, and they've got to fund that because the developers left the room. So the lenders have become far more circumspect. Now, I call that an element of co-regulation, that if actually you get the lenders starting to be more cautious. And I remember when I first sat down with the banks at the beginning of this and said, hey, you guys have got to do some heavy lifting. You lend to people who've got no credo at all, and you don't even pay any interest in whether their drawdowns of their projects are in fact related to the project. And you might recall the Raylan project out at Rockdale that just came onto the scene as I was appointed, where on that project, the developer had absconded with money that was drawn down from the lender and used it on other projects, not on that project. So I said to the lenders, you guys have got to start to do some strokes here, because this is your money, and I understand when you lend it, you'd like it back. So that's a co-regulatory activity. And so ICERT has provided, because the regulator can't provide certificates of trustworthiness. The regulator's got to focus on risk, not trust. And so ICERT is very much a trust-based response, and I'm pleased to see that the Minister and the Commission has continued to push that proposition. But LDI, this 10-year warranty insurance, I think it'll be called DLI, Defects Liability Insurance, that's got an element in it where the insurer requires the developer to engage a technical inspection service from day one, from the day the design starts to the day that they apply for practical completion. And this is a really, through the entire process, technical inspection service. And before the DLI policy can turn on, a satisfactory report from the technical inspector has to be given to the insurer, because they've got skin in the game, because they've got first resort exposure here, so they've taken. So it could well be that in fact the technical inspection service market's going to create a market demand for this service, because I think if the private sector can provide this chain of custody technology, I think it'd be far better coming from the private sector than perhaps it being embedded from day one in the public sector. These things were always going to take some years to mature. I remember Mr. Shoebridge telling me that, why can't this all be done in 2 or 3 years? I said, well, Mr. Shoebridge, it's going to take at least 10. And you need to just bolt up and go on that journey. And I think these are the sorts of things that are going to come. So I'm very hopeful that the insurers, who really are underwritten by global providers, and I met a global provider a few months back because they came out to interview me about this long chain custody stuff. I think they will solve this. So I'm very hopeful that about the time that this flow of offshore buildings arrives, that we'll actually have some capability to look back up and be confident in them.
Excellent, thank you.
Dame Judith in the UK called that the golden thread. So they're still struggling, by the way, to achieve what they call a golden thread. So it's worthwhile just following that, but right now they're floundering a bit there. But I think we might move a bit quicker here.
Thank you.
Thank you so much. That's been a very, very interesting session. To the extent there are questions taken on notice or supplementary questions, the Committee Secretariat will be in touch. But that concludes our session with you today. Thank you.
Thank you very much, Chair.
Thank you.
Thank you all.
Thank you, Mr. Chandler.
I haven't retired, by the way.
We can see that.
Notice, Chair.
Thank you.
Thank you.
Great. We now welcome our next witnesses. If I could begin starting on my left, if you could please state your name and position title and then swear either the oath or the affirmation.
Certainly. Thank you. My name is Stephen Pearce. I'm an architect and I'm representing the Association of Consulting Architects. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you.
My name is Peter Smith. I'm a registered architect at Smith & Sons and I'm representing the Association of Consulting Architects. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you very much. And would you like to commence with a brief opening statement?
Yes, I will. Thank you. Firstly, thank you very much for the opportunity to talk to you today. As I've just said, I am representing the members of the Association of Consulting Architects, and together with my colleague Peter Smith, who is very active in the residential architectural practice world. The Association of Consulting Architects is Australia's peak body for architectural businesses, representing 850 firms nationally and 260 in New South Wales. So we work in alignment, if you like, with the Institute of Architects, but we are more representative of the business side of architecture. And last year we lodged a submission to the Minister and the Commissioner on the building bill, which was relatively detailed about our support in general for the bill, but about issues pertaining to its implementation. And some of those were the impact of the unclear definitions within the bill, and one of those things just is the use of the word design often is bandied around and nobody really has a clear understanding of that, and different legislations refer to it differently. There was also the potential of a watering down of consumer protection through inadequate education and training for certain design practitioners when they have an ability to work out of very detailed and more complex building types. Insurance implications and costs to business. More recently this year we undertook a detailed member survey because we really wanted to see how this rollout was actually working. And we undertook that with our colleagues at the Regional Architecture Association, so our reach was into the regions, not just city-centric. And the results were quite alarming. While the Act and the planning portal have very worthy objectives, they created a regulatory burden that is quite frustrating, and it's complicating the industry's ability to deliver and its business productivity. And some of the key things that came back from our members, and this is just a short capture, developers and builders that are abandoning Class 2 apartments for simpler buildings. There's a lack of regional consultants, largely due to the complexity of actually getting aligned to the Act. Unreasonable impact on small renovations. This is a particularly tricky one for Class 2, and excessive compliance costs. For simple things like multi-generational living or putting a granny flat in your house. We also have very strong response at serious shortcomings on the online lodgement system, known as the portal. And this is a fundamental thing in the implementation of the Act and the day-to-day business. So we've heard that excessive times of up to 1 to 1.5 days to lodge your application, which used to be a 3-hour visit to council. Regular system crashes and outage, disrupting daily operations. Double and triple entry of data in just a simple application. That explains why it takes so long often. And there's a lack of support from the Building Commission on matters to do with the Act and the portal. So how to actually make it work for your business. So we're here today to really talk through any of these questions, obviously, that you might have about our submission, but we'd like to also be involved in an ongoing discussion because we think this is an evolving, as I think Mr. Chandler just said, there's an evolving Act and bill. We support the implementation of it and the thrust. We just want to get it right. And thank you for the opportunity.
Thank you. Do you wish to make an opening statement as well? Or?
No, I think we just go straight to questions.
Thank you very much. Thank you very much, Mr. Pearce. Questions from the committee? Absence. Kate?
Yeah, sorry, I thought you'd were going to go first, Chair. Thank you for your submissions to the inquiry. I wondered if you were able to expand on your, you talk about the cost explosion in relation to the DBP Act, whether you can kind of expand on that, tell us why, what's behind that, and also whether, actually no, we'll start there. I'll see if there's follow-up from that.
I guess what we have with the current DBP Act and the regulations and guidelines that fall with it is a one-size-fits-all approach. Now, housing in New South Wales kind of spans a very large spectrum, and in the Class 2 spectrum, it could be anything from a simple villa development with car parking underneath it to a 50, 100-storey apartment building with kind of 1,000 apartments kind of within that. But the same system, the same requirements apply irrespective. Just to give an illustration, our office, we generally don't do very, very small projects. We tend to do mid to large size projects, but we've done 3 bathroom renovations this year. Those bathroom renovations in an older apartment building, a building where the bathroom really did need to be renovated to be habitable, kind of resulted in a series of documents kind of that required documentation from waterproofing consultants, from a structural engineer, from a hydraulic engineer, a mechanical engineer, and a kind of notes here before, and various other consultants, all up, that would have been a cost of around kind of like, if each consultant had a fee of $5,000, which most of them are much more than that, and if you're looking at kind of like $35,000 to $70,000 in consultant fees for a bathroom renovation, kind of that only costs around $20,000.
How big is this bathroom? It's for
Exactly, it's a very small bathroom, but this is triggered. Imagine you have a small apartment bathroom, and outside that bathroom you have a cupboard. So it's outside the perimeter of the bathroom. Yeah. So you decide, I don't use that cupboard very often. I want to move that wall and incorporate that cupboard into the bathroom. That triggers the Design Building Practitioners Act and triggers kind of like the list of consultants and the list of documentation that's required for that bathroom. Now, surely the risk kind of that bathroom being done, now I can have the best waterproofing documentation you can have in the world, but there's no guarantee that that's actually going to result in that waterproofing not failing.
Yeah.
So it is ensuring that the documentation that's been provided, and with support, kind of a lot of the work's been done to ensure that large projects have the documentation, the set of instructions, so that when it gets to site, the builders know what it is they need to build and the regulations they need to meet. True, in a lot of circumstances that wasn't provided in the past, but it's ensuring that that documentation is appropriate to the scale of the building. And that's one of the areas in which the we're seeing a huge amount of regulatory burden and a kind of additional work that just look at it and go, this is just unnecessary. It doesn't actually necessarily deliver that outcome. The other side of it is the way in which there's a double up in the approval process and the delivery of that information. So the Design Building Practitioners Act sits beside the Environmental Planning and Assessment Act. And so we support the idea that the building bill would bring all that together, but it still duplicates the process. So you've got what's known as the construction certificate, which is the documentation you provide to ensure that the building complies with all the regulations and codes. Mm-hmm. What the Design Building Practitioners Act has done is replicated that process for a very small number of building components. Now, those building components, such as fire rating, waterproofing, already had to be certified by the certifier and already had to demonstrate compliance with that. But what has occurred, now you have additional forms, and the crazy bit in this world, they're actually paper PDF forms that you have to sign out and fill out for every piece of paper to say that this drawing here relates to fireproofing. And that same drawing, you might have also your waterproofing notes on that same drawing. You've got to fill out another form to say that that same drawing also deals with waterproofing. You just go insane with actually preparing the application, kind of for sometimes very, very simple projects.
the same issue occurs with, say, a balcony on an older 1970s apartment building that may have a water leak. It may actually trigger enormous compliances all the way through handrails, at every other element, which might turn a simple leak fix into a $70,000 or $80,000 renovation plus $30,000 to $40,000 worth of consultants. And we have been involved in one of these recently. So it's not that the intention isn't correct, but we feel that it could be streamlined. There could be more of a drop-down menu approach to how the complexities of the implementation can be dealt with to suit the scale of the actual issue, and that's not reflected in the current Act.
So to that-
Okay. Sorry, can I do a follow-up, Scott?
Yeah, of course, Ken.
Thank you. So just on that, firstly, just assuming that, did you both say that you've seen the draft building bill, that you've been consulted on that? No.
No.
I have.
Okay.
I found it on the internet 2 days ago.
Yeah, we're being told that that's an old, but anyway.
That might be the current version.
It's not for lack of trying.
Yes.
We have been in discussions with the building commissioner about it, but we have been told the bill is not available for review, and that we've been waiting for a while. So we have also entered a lot of discussions with the building commissioner about in supporting the bill, but it's subject to seeing the detail, of course, like all of this.
Yes.
And that's still a problem.
Exactly. So I was going to ask you in terms of exactly what would be taken away in terms of all of that, the various certificates that you're saying has been required under the DBP Act, and what streamlining means to you, and whether you know that this is actually taking place in the building bill. But if you haven't seen it, but you've had discussions, and you think that this is what it will address?
No, we have discussed higher end issues around the definitions, the design practitioners' definitions, the role of building designers and architects. But we've submitted the detailed questions, but we have no response. We've also been trying to meet with the building commissioner, and there's been some, they have said they would like to meet with us and have a round table, but I suspect they might be waiting until our presentation to this commission might be concluded, and I'd like to think we'll be able to do that very soon.
So in terms of, to answer your question, what would we like to see? Essentially, we'd like to see and to be honest, most of it's actually to do with the regulations and guidelines that follow kind of with the bill, which this is where the problems actually occur. It's in the detail rather than the high-level principles. And essentially, a list of requirements for documentation that are supplementary, not to a separate process, but part of the construction certificate process, that are consistent across the board, so everybody's working to the same kind of list of documentation, and that list of documentation is tuned to the scale of development, so that you're preparing the documentation that is appropriate for the scale and complexity of the project that you're working on.
Yeah, I mean, that sounds really reasonable to us.
I mean, if I may, there's just one other thing, that in the class 1 and 10, there is this document that's been prepared as a tool for teaching and TAFE. This is how to build a residence, and it outlines all the key details. If there was a potential for some standard documentation, because we believe about 70% of our buildings apply similar construction techniques, we may well be able to be moving quite quickly, because this document can be a reference. It could be the building code or others, but somehow we begin to remove this complexity of the interpretation of all of these details and put the, the onus correctly on who is implementing these. And we feel that is, we need to get the complexity understood in the documents, but the builders need to be able to build it, and the trades need to be trained and educated and see how to put it together simply.
Mr. Pearce, can you just read out what that book title is for the purposes of Hansard, so it's on the record?
The Acceptable Standards of Construction, Class 1 and Class 10 Buildings, Best Practice Reference.
How many pages there? It looks about 300 pages. What is it?
But it's got it is, I mean, 150 pages, but it'll also tell you how to build a timber deck.
Great.
So
No one's ever worked that out before. We've only been building houses here for 200 years, but anyway.
So, I mean...
We also did just hear about modern construction, though, from Mr. Chandler. So just that book would have to need a few updates occasionally, wouldn't you?
It would, and look, I'm not saying that it's the answer to everything, but we are seeing that a large number of our buildings are built in the same way. The modern methods of construction are going to be very important for a percentage of our buildings, which will grow over time. But we're in this transition phase, and I think, as even Mr. Chandler has acknowledged, that there's still complexities in getting that right. But we need to get the next 10 years done, and we are concerned that these incredibly onerous calls for documentation aren't necessarily getting us there.
Mr. Barlow.
Thank you. Look, my question was largely going to be Ms. Fanman's question as well, but in terms of what you understand at the moment and changes, is the government at all open to looking at sort of what you say in terms of the drop-down menu, so to speak? So there's a bit of a variance with respect to risk as it approaches a new building bill or the new compliance system with the building commissioner?
We haven't had a response. We have sent this, our document, our draft, your original draft that came to this committee, to the Commissioner's office.
I think,
and obviously they're all now public, but we need to take that up. We are hoping we'll get a seat to discuss and have a round table. We would like to bring experts along, and like Peter and the rest of the team that are involved in this, to actually talk through. And we've got probably 30 or 40 clear recommendations of simple things to be looked at. The portal is a big problem, and it's a cost burden on practice, and particularly small practice. And it's not fit for purpose, we don't feel, for this current environment. It's being asked to do too much. It's an ant that sort of had an elephant put on its back, and unfortunately,
great description.
We're hoping, and possibly Peter might talk to this a bit more if the committee would like.
Yeah. So tell us about the ant with an elephant on its back.
Well, it's a system designed for fishing licences, and I hate to say, I'm not a very good fisherman, but I do know that fishing is far less complicated than building a building and lodging a development application. I was involved with the Department of Planning kind of in the best part of about 7 years ago on the drafting up and scoping of what the planning portal could look like. And there was a lot of work done by kind of external consultants and also industry in shaping what that would be. And my understanding is that that was all kind of put out to tender and priced, and then Service New South Wales looked and said, oh, so we have kind of like a lodgement system for kind of creating applications. And so it got shoehorned into that. And since then, having seen what was possible, having seen what is available in other jurisdictions, and seeing what we've got, it is laggy, it crashes, it asks repetitive questions, it is unintelligent, and the interface is confusing. And it's quite embarrassing for New South Wales to have that as being our primary way of dealing with development applications. And there's a lot of improvement that could be done. I'm not a technical person kind of in terms of the IT space, but kind of would be questioned whether the infrastructure is actually sufficient to support the extent of applications that are needed to actually get New South Wales moving again in the building space.
No, I'm not a technical person either, but often I hear that it's the challenges with the APIs between different systems as well that are, communicating. And some people seem to have worked it out in a sense, and then others haven't. Yeah. And there seems to be a variance as to how people deal with it. And even, I've got to say, in terms of some of the certifier space, I hear that there are some certifiers that may have worked out that system, and then it might be their architects, it might be a whole range of other people that are using their workarounds to try to communicate with the system, but it's
we quite often do a double application, so you put your application on the portal and you send them an email, or kind of like get a Dove or something like that to fly the application off to them so they can have a paper version. That's usually more efficient, unfortunately.
Now, with respect to your and it's just lunacy, really, your example of the bathrooms and the consultant's reports for what are a relative small renovation when it comes to a building like that.
Yeah.
What should be the ideal? What do you think should be the requirements when it comes to something like that in a residential apartment building, and how should that be reflected in the Act?
Yeah. So for a small bathroom renovation, most of those details are, for example, the installation of a mechanical kind of system is pretty standard. It's about compliance with well-known standards that most mechanical installers have been using kind of for decades. So as has always been the case, kind of documentation is prepared and the construction certificate requires that new building work complies with those codes. There doesn't need to be kind of instructions at that simple level for a mechanical engineer, for a mechanical installer to install a fan, like one of those IXL Tastics into a bathroom.
Yep.
You don't need a drawing to do that. When you move into larger, more complex buildings, such as apartment buildings that might be kind of like 5, 6, 7 stories, you have a multitude of contractors and you have a multitude of services that are kind of sitting on top of each other. That does need to be documented. That does need to be properly coordinated to make sure that everything all fits together and everything works and that the building at the end of the day complies. So it's looking at the level of documentation, the level of design work that is needed for the complexity of building, and ensuring that the guidelines are actually responding to that, so that when you're doing a bathroom renovation, you would have a simple plan that essentially has notes saying, look at the Australian standards for how to do this work. The Australian standards have been there, they're in the library, they should be accessible for free, but they're there. Where you're going to a larger development, then you need those more complex instructions. Where there is a hole is actually in the delivery of all of that. As Mr. Chandler pointed out, at the moment, the regulations only require that 10% of bathrooms in any building are actually inspected during construction. Now, if we have a problem with quality of construction, if you have problems of quality in any other industry, what do? They increase the amount of inspections. They actually look at where a building is failing. Now, good builders today, those ICERT builders that the former Commissioner was talking about, they now, on their own bat, go in and employ waterproofing experts to inspect every single bathroom, to water test them and everything like that. If we have a problem with quality, that quality, you can do the best documentation, you have the best instructions, kind of like in the universe, but if people aren't following them, people aren't checking that those are followed, then there's still a problem in the system. So looking at in the regulations how the builders can be supported, how inspections can be done at a point which doesn't increase the length of time it takes to build a building because they're done kind of at early stages and done regularly, would ensure that we end up with buildings that are built correctly and won't have the defects kind of into the future.
Thank you. Mr. Latham, did you have anything?
Yeah, I wanted to come on to the waterproofing fetish that seems to have emerged. I don't know why you need engineering reports about that. And isn't it also true that it's an inexact science? You don't really know if waterproofing works until water is on the surface, and because for the simple reason buildings move. And you know, I can tell you my own experience with waterproofing in a variety of residential buildings, but why have we become so finicky about this?
Yep. We've become finicky about it because it has been probably the most significant failure kind of most buildings, and probably since the 1950s, kind of like all those flat roof buildings we did, they all leaked.
Buildings move, don't they?
Yes, they do, but waterproofing systems and technology has advanced such that if you choose the right type of membrane for the substrate, it will actually, it has elasticity, so it does move. Now, waterproofing systems don't last forever. Most of them have 10, kind of 20, 30 year kind of lifespans, but the reason why you would engage with a waterproofing consultant or a supplier of a particular waterproofing membrane is to ensure that the membrane you are choosing is appropriate for its purpose. For example, if you're putting membrane on a roof, you need to make sure that that membrane is UV kind of resilient so that it doesn't break down in the sun.
Right. But wouldn't tradies know that? I mean, regulation seems to become a substitute for tradie knowledge.
Yes.
Buyer beware. Normal processes of inspection as a house or apartment is being built, and then ultimately, water goes on the waterproofing, and you find out how good it is.
Yeah.
You know, this is the practical lesson of life, isn't it?
So I think part of the answer to that is that we've
And
now
if there's
entered
a
a
defect,
world of...
you've got
it
a
is.
contract under which you can get it fixed.
Yeah. Hopefully you don't get to that point. Hopefully you get the stuff right in the first place. Part of it is actually the complexity of products that are available at the moment.
Right.
Like 15 years ago, there'd be 3 waterproofing products available. Now you've probably got 50, you've probably got 500. So understanding which is the right one. But then secondly, we've also entered a world where quite often the way a building is delivered is not that the waterproofing contractor is the person who actually goes out and buys the membrane. It's the one he's been using all the time. Quite often the membrane might be bought by the builder, kind of the waterproofer just comes on site and just applies the membrane, and it may not be familiar with that. So there's some holes in some of that training kind of as well, of ensuring that the waterproofing applicators know the system that they're working with. But yes, if you have a good waterproofing applicator, they're licensed, they will know the right membrane. But
Of course.
there's it's a bit more complex in the world today.
If I might add, just another point on that is that the nature of how we deliver our buildings has changed dramatically, and that originally, I guess we're referring back to a situation where a builder would understand everything that's going on that site and daily walk the site. And a lot of builders have become more managers and relying on the trades. We had quality assurance brought into the system quite a while ago, where the trades were asked to self-certify, and that sort of led to a loosening of control and in some cases failures. And that sort of system has expanded so that who is responsible became more muddy. So I think if the builder was walking the site and doing as Peter has suggested, that they're inspecting every item like they might have done 30 years ago, but we don't believe they do anymore. It's a different building practice, a nature of building, and you need these experts to actually inspect through the process. It's much easier to fix a little bit 3 times to get it right with the trades than pull the whole thing out at the end, as we would know.
Maybe I was living in Mayor in the wrong spot, but I'm interested in what's changed there. The pattern was that the builder's in a ute. He's probably got about 5 or 6, 7 building sites going at once. Be proud of the trades that he's got, reliable people, and he'd spend maybe half an hour on each of these sites as he goes from site to site. And if he's a particularly good builder, well regarded, it's nothing just to rip up the skirting boards. They're not straight. That's not how we do it here. Rip them up, tell the trades to start again, otherwise they'll lose the work. So how's that changed? Isn't that sort of your basic, in practice, quality control?
At that scale of builder, that still happens. You rarely actually get problems with builders who operate at that scale because they are hands-on. But what you do see now is at that next tier up, kind of like the next tier of contractor where they've expanded, kind of they're taking on more work and they don't have the supervision on the sites. And also you have then contractors are coming in, kind of like there's not as many contractors in the industry as there used to be, and so everybody's all time poor, so they come in, kind of rush to do the job, kind of then go off again. And so there's, in that kind of next tier where there's less supervision, things slip through the hoops. Yeah.
Mr. Primrose.
Oh, look, given the time, we had an interesting discussion previously about the differentiated compliance pathways that you've mentioned. So I was just wondering if I could ask, maybe take it on notice, if you could just give us some examples of some of those differentiated pathways, what they would actually look like. Now, no great detail, but simply, look, this is what you believe this degree of regulation is appropriate as opposed to this, and this one. I think that may assist us in terms of drafting out final reports and things. If you take that on notice, that'd be great. Thank you.
Thank you. Our time with you has come to an end, unfortunately. Thank you very much for your attendance and for sharing your thoughts and expertise with us. To the extent that there were questions taken on notice or supplementary questions, the Committee Secretary will be in touch, but that concludes our session with you. Thank you.
Okay. Thank you.
Thank you very much for your time.
We now welcome our final witnesses for today. If I could ask each of you, starting on my left, to please state your name and position title and then swear either the oath or the affirmation.
Christy Lee Eulenstein, Head of Policy and Government Relations at Consult Australia. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you.
Alison Kirk, New South Wales and ACT Manager for Consult Australia. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much. And would you like to commence with a short opening statement?
Thank you. I'll provide opening remarks for both of us.
Thank you.
Consult Australia is the industry association for businesses in design, advisory and engineering consulting. Our members are captured by the Design and Building Practitioners Act as design practitioners and/or professional engineers. We represent businesses of all sizes, from complex global companies, large Australian businesses, as well as small businesses and sole traders. Around 97% of our industry is small businesses, and by that I mean 20 or less people. Our members supported core aspects of the building reforms, including the measures to ensure there was a focus on quality design before construction starts. However, as we've set out in our submission, our members are struggling with key aspects of the legislation, including the complexity of having to deal with the Act, the regulations and the Code of Practice. This is especially so for those small businesses that dominate the industry and do not have in-house lawyers. The key recommendations I'd like to focus on today are the following. We suggest that existing buildings be excluded from the Design and Building Practitioners Act. Our members that do remedial work on existing buildings have significant concerns about the application of the Act, especially where the non-compliance of the building elements is due to changes in standards and do not necessarily create a safety issue. Our members believe, Our members believe that the solutions they must suggest to consumers are often cost prohibitive. Often replacement becomes the only option, despite what the owners want or need. There seems to be no room for reasonable exemption under the Act for existing buildings or elements, and the current exemptions don't seem to apply to these situations. We suggest removing the insurance requirement on practitioners to confirm the adequacy of insurance. We agree that the Act should require that practitioners are covered by insurance. However, we believe it is difficult for practitioners to determine if their coverage is adequate for several reasons. Firstly, practitioners often do not have access to their company's professional indemnity insurance policy, except for sole traders, of course. This is particularly so in complex global or large businesses. Secondly, as you would all have experienced with your own car insurance or home insurance or contents insurance, you don't really know if your cover is adequate until you lodge a claim and see if the insurance pays. Finally, because of the broad duty of care and the potential to be held liable for all loss, not just the loss that you contribute to, also adds to this problem. We also suggest modifying the duty of care to guarantee proportionate responsibility. This would assist to ensure that a practitioner's professional indemnity insurance can cover for the loss they are liable for. Secondly, it would assist the insurance market to have more affordable PI insurance available to practitioners. As you know, insurers price risk. Therefore, even if no claim is made against a practitioner working in New South Wales under the Act, the fact that there is a risk of claim, because it's in the Act that the practitioner could be held liable for losses beyond what they contribute to, this risk needs to be priced, and the insurance industry does that. I also believe that the decennial liability insurance should now be the first port of call, and so there's no need for this broad application. I have a member example that illustrates the importance of the above three recommendations. A small business member inspected a 20-year-old roof structure made of glass and aluminium. It was leaking. They identified that the holes built in the weatherproofing systems are impossible to totally plug. The practitioner is actually confident that they can make the structure perform better, but is questioning if it is worth taking the job. Under the Act, the practitioner is required to make this structure compliant with current standards. The practitioner is also personally liable, which could include liability of the original design and/or construction, despite having no role in that. The practitioner believes the only way to eliminate the risks of past work is to redesign and rebuild this roof at an exorbitant cost to the consumer. That's all I have for now. Thank you.
Thank you. Okay, so we can start with questions. Just checking, Ms. Fairman. Actually, if I could go to Mr. Farlow first.
So you seem to be in the interesting position of trying to do your members out of a job here, in a sense, by saying when it comes to particularly existing buildings that that's a completely onerous position. So obviously, for your members, they're pulling their hairs out in doing some of these assessments that seem unnecessary, and as you quite succinctly put, are leaving people to actually say, well, the only way we can do this is by demolishing the building because we can't afford it. So obviously your members have grappled with this to give this kind of feedback. Just interested in terms of, similar to the question I put to our previous witnesses, what do you think is the optimal system there? If you are to take this off existing buildings, what sort of checks do you think are necessary to ensure you've got compliance, that we don't see further issues in a building, but also ensuring that it's not overly costly for residents?
I think the ACA put it very clearly that different regulations should apply for different classes of buildings or complexity of buildings, but also there are existing certification requirements, exemptions, etc., that already apply and applied before this Act came into force, and that seems appropriate. Our members are the members that have contributed, especially to those sorts of examples, do work a lot in the maintenance space, and so have gone back to fair trading a fair few times with questions about the current exemptions and whether there's any possibility that it would fit, and we just can't get any flexibility. So I think I can't talk too much about all those structural elements our members tell us because they're the experts, but we certainly got a plethora of different examples on existing buildings which just seem there seem to be no safety issue according to our members. It really just comes to the cost to consumers, and as you say, they don't actually want to just make money out of consumers. They're actually interested in solving problems. Engineers love a problem they can solve, and so they're more interested in solving the problem rather than just getting rid of the problem and putting a new structure in or whatever needs to happen.
And I guess when it comes to this, effectively, like the impetus, of course, when the Act was what we saw with Mascot Towers and Opal Towers, and there are certain things you would want to do moving forward, certain standards you'd want to employ, but when you're trying to apply those same standards to existing buildings, it becomes very, very complex.
Yes.
Now, in terms of some of the other challenges that your members have found with the Act, have you had any discussion in terms of the prospective building bill and whether these will be picked up in that potentially with the government?
Well, our understanding is that a lot of the current design and building practitioners bill will simply just be rolled over into the building bill, and less of these issues sort of being addressed before that happens. Consult Australia, when the design and building practitioners bill was being developed, did say that we should make sure that we just have one bill. That would be great. That would deliver everything we need for buildings in New South Wales to bring that confidence to the market and to bring clarity to the industry. And I feel that we have potential with the new building bill, but not if we just simply roll in aspects of acts that are still problematic, that have never been ironed out or fixed.
Thank you.
I'll go to Ms. Fairman.
Thank you, Chair. Thanks for appearing today. I just wanted to go to some elements of your submission. The application to existing buildings, and you, with where is it? You say practitioners must have lengthy discussions with inspectors from the Building Commission and Fair Trading. I can imagine that would be incredibly time consuming, and that there wouldn't be enough in terms of the staff at the Building Commission / Fair Trading. Could you explain, just talk us through that in terms of what you're hearing from the businesses you work with, because we hear obviously from people all the time the delays in dealing with fair trading on other issues. Firstly, I assume there isn't enough capacity to deal with all of the, because waterproofing particularly, of course, is a massive issue here in Sydney on a lot of buildings.
Yes, certainly. So members report that they quite often have discussions with the Building Commission or Fair Trading to try and get resolution to these issues. I think not only just the level of staffing, but the knowledge base of the staff is really important. So obviously when members give me examples, I can read them off the page, but if you showed me a plan, I personally, as a lawyer and a scientist, probably couldn't point out the issues they mean. So obviously with public servants, we would need to make sure that the Building Commission has that mix of, you know, the policy experts that are needed for the everyday work of being a public servant, but also that expertise in building design and engineering, which there's a shortage in the industry already doing the actual work of consulting engineering. Then putting those in staff is tricky. So I think our members would suggest that it's not just about the number of people that are in the Commission, but their skill level and their understanding of what a consultant engineer does, what a designer does, and the limits of those and the building code.
And in the previous question that Mr. Scott Fallow asked, did you say that you had seen and been consulted as part of the draft building bill, that you'd seen that bill and you're part of that formal consultation with the government?
I might hand over to Alison because I can't recall. I see so many bills around Australia. I'll point to you about where we're up to on that.
No, we haven't. We're aware that it's in progress. We have met with the Commissioner, but no, we're not part of the formal group and haven't been consulted. Yes, we have submitted a submission on the bill.
And it was open for consultation.
There's a submission that was on the 2022 bill. That was, is that correct?
Yes.
Yeah. So when you are saying that you believe that existing buildings should be excluded from the DBP Act and the practice standard for professional engineers, does that go into the building bill as well?
So as far as we understood, the building bill 2022, as we saw, that was open for consultation, did seem to roll in much of the Design and Building Practitioners Act and the regulations. And so, and we didn't see any core changes to the elements of concern such as insurance, a duty of care, etc., and the application to certain buildings. When it comes, just for clarity, when it comes to the practice standard has been developed by the Building Commission, but it has not yet been released or enacted, and we are waiting for further advice on that. We have serious concerns about the practice standard. We highlighted a few of those in our submission. So we are hoping that the practice standard will be stalled because it's important to iron out the existing problems with the existing legislation before you roll on more compliance onto an industry that is already struggling to make sense of what the obligations are, how to comply, and then how to get advice when it seems like it's nonsensical for the Act to apply in certain situations.
Okay. Thank you. And so with the just to be clear, in terms of the consultation on the building bill, that's with the building commissioner, not at this point the minister or the minister's office?
No, we haven't been consulted at all. Yeah.
Okay. Turning to insurance now, I can see that. So, could you talk us through what's the problem in terms of the practitioner needing to confirm the adequacy of insurance coverage versus the practitioner just, I assume it's just ticking a box saying they've got insurance. Is this because they have to have a form that they have to submit and it's time consuming, or is it more than that?
No, it's more about, I personally would not sign anything saying I ensure, I am absolutely positive that my insurance is adequate for all possible losses. I can't ever prove that. I don't know. And I just don't think it's fair on practitioners, especially when they work in a business where they have no say over the policy that is held by the business. These practitioners within a business, unless they're sole practitioners, do not have any liability, do not have any ability to go out into the market and source insurance, and they rarely, if ever, see the actual policy that is covering the business. So I think it's just unfair to require a practitioner to affirm the adequacy of insurance cover. I also think it's very difficult, even for a business that knows the cover, to say that it is adequate, given that the duty of care is so broad and there is that possibility of liability for other for loss that others have caused, rather than just ring fence to the liability that your business or the practitioners within your business cause. So it's less about the forms, it's more about the fairness of having to make that statement. As you would, as I alluded to in my opening statement, can we really ever be certain that our insurance that we have for our car or our house is going to cover all loss? We don't know till we put in the claim, and we hope. But, it is up for the insurance company to dispute it, etc., etc.
And are you finding that people are, certain businesses, practitioners are shying away from particular jobs, or it's making them nervous, leaving the industry potentially because of this situation?
Definitely. Yes, we've had a number of small business members say that they will not do work in New South Wales under the Act, that captures under the Act. And we have one example was a business that was going to provide advice to another business who was working under the Act, and they just thought, the risk is too high. I already have trouble getting insurance because I'm, a structural engineering business. Structural has some, structural engineering is still one of the hot buttons for PI insurance, where the market is still a bit hot and hard to get adequate and affordable insurance. So they've bought out of that market. And Alison, I know, has an example of a business locally that has actually had to close because of the Act. If you want to share that.
Yes, as Christy said, yes, we have a number of members, but one that has closed because it was quite significant. And I might just read what is in our submission here. Business is now very challenging in the face of increasing regulatory runoff periods combined with rising insurance costs. This is a massive change in the playing field since many businesses were started. We are facing the need to fund runoff costs in the high hundreds of thousands of dollars and possibly millions by the time I come to retire. When I started, this was more like $20,000 total. There is simply no way a small business can set aside something like $100,000 per year for the last 10 years of business to fund $1 million of runoff costs over the following 10 years, which takes us nearly until we reach 75 years old. This is a huge challenge, and one that is putting people off starting new businesses now and is causing significant stress among most business owners that are over 50.
Any further questions?
Not here, but Sarah Mitchell and Greg Donnelly haven't had a chance to ask questions yet. So.
Yeah, no.
No?
It's fine.
You're good? Mr Primrose?
No, we're fine, thank you.
I've got one if I can, Chair, sorry.
Yes, go ahead.
Hello, hi everybody, thank you. Thank you for your submission. I just wanted to ask, and you sort of touched on it just then, I guess in terms of the impact for business, but in your recommendation 9, you talk about better education to the industry in terms of the regulatory framework, and I'm just wondering what exists now, if anything, and are there things that this committee could be recommending in that space?
So currently, I don't know if you've visited the website, the Fair Trading website for design and building practitioners, but I get lost.
It's too complicated for us. We're only members of Parliament.
Well, there you go. So I keep going around in circles and cannot find. So I was actually trying to find last night the full name of the code, and I couldn't find it. I was going around in spaces. So the website, which Fair Trading keeps telling us to direct our members to, is difficult to sort of navigate. As I say, the expertise within the public service needs to be uplifted. If you're a regulator into design practitioners and building, you should have, broad knowledge of those aspects, or have people available to you who can answer these questions. These are, I get a very sore brain when I talk to our engineering members because they are very smart and they say lots of things I don't understand. So it's really important to understand how all the codes interact, the building codes, etc., and therefore how they can apply to all of these vast situations. And I think it's just more open communication when the Commission is making changes or considering changes to regulations or additional things such as the practice standard, which was, a real hot button issue for our members. Members were very concerned about that, so we are hoping that that will not proceed at least until after we get clarity on the new Building Act.
Thank you. Thanks, Chair. That's all I have.
Thank you. Well, thank you very much for coming along today and for your submission. To the extent there are questions on notice or supplementary questions, the Committee Secretary will be in touch. But that concludes our session with you and our hearing for today. Thank you.
Thank you.